So the first thing that many of us learn about America as we grow up is our country's historic dedication to preserving religious liberty and the right to free exercise of religion. And we learn that our country has largely gone about this by means of the religion clause in our Constitution. Now, in recent years, we've seen a political and legal shift towards a school of thought called accommodationism that is used to interpret and apply the religion clause. Accommodationism calls upon the historic, positive, very public role that religion, and in particular Christian religion, has at times played in American society. People in favor of accommodationism argue that we should return to this, and they largely go about advocating for that by saying that religion and religious actors should be exempt from generally applicable laws. A good example of how accommodationism has become more widespread in recent years is Indiana's recent and quite controversial Religious Freedom Restoration Act. This act, in effect, allows a business owner to choose not to serve an individual because that individual's lifestyle violates the business owner's personal religious beliefs. Now, opponents of this bill say that it essentially allows discrimination against the LGBT community in particular, while those in favor of the bill argue that it is essentially about protecting religious liberty and the free exercise of religion. For my thesis, I decided to see if and when we see this shift towards accommodationism in the Supreme Court's religion clause jurisprudence, or the way in which the Supreme Court interprets and applies the religion clause. In order to go about this, I selected 6 religion clause cases the court has handled since 1990 and conducted a thorough qualitative analysis of each of them. What I found is that we do in fact see a shift towards accommodationism around 2005, and that the court has consistently applied this approach to religion clause cases to every case since, all the way up through Burwell versus Hobby Lobby, which was decided last year. Now, it is important to understand how the Supreme Court interprets and applies the religion clause, not in the least because of the historic significance our country has placed on how we treat religion. But it is also important to study and understand the implications of the Supreme Court using accommodationism in particular to interpret the religion clause, so that we can better predict how the court may decide on religion clause cases in the near future. So if someday soon Indiana's Religious Freedom Restoration Act comes to the court for them to either uphold or strike down, understanding accommodationism and how the court applies it will help us to better predict whether the court will strike down a law that may allow discrimination or whether they will uphold it because it protects the exercise, albeit the very public exercise, of personal religion. Thank you.